recording now.
So there are important terms in intellectual property, so copyright, trademarks, and patents. Copyrights cover works of art, music, and literature, which would include sports such as rhythmic gymnastics, synchronized swimming, figure skating, ice dancing, and sport. These are specifically protected under the copyright law. Trademarks cover name, images, slogans, and phrases. Trademark laws protect businesses' commercial identity, or brand by discouraging other businesses from adopting a name or logo that is confusingly similar. And patents, a patent is a form of intellectual property that gives owner its legal right to exclude others from making, using, and selling and importing an invention.
All right, so as another introduction to intellectual property, so why is it important? So intellectual property protects the exclusive rights and controls like intangible assets. How it can be seen relevant today in sports, like if you look at the top three logos, all of those teams, like obviously one of them being Florida State College, which we'll touch on soon, as well as the Redskins, all have had their issues with the rights of using these logos, but how it's relevant specifically is these disputes are over the usage of these logos, and intellectual property protects the rights to use the shape, configuration, pattern, and ornament design of these products. And where it's most commonly seen, as I touched on previously, Native Americans have often claimed intellectual property rights over the professional teams and the colleges that are using their image or their background in the form of their mascots and logos.
So moving on to our case, we decided to do Black Horse versus Pro Football Inc. And basically, the case follows the historic case of the Pro Football Inc. versus Harho. The case originally was ruled on by the United States Patent and Trademark Office, the USPTO, where it canceled trademark registrations of the word Redskins on the grounds that the subject marks may disparage Native Americans and may bring them contempt or disrepute. So the owners appealed the decision, and the courts reversed the USPTO's decision on insufficient evidence of disparagement. Subsequent appeals had been rejected on the basis of laches, basically meaning the Native Americans filing suit in the future were well past the time in which the trademarks had been in existence. So they could no longer kind of file suit. So a younger kind of group of people would have to come in and kind of apply their case or file their case.
So the Washington Redskins used the mark the Redskins after the team's owner, George Marshall, selected the name. The Black Horse defendants wanted to cancel 6 of the plaintiffs' trademarks registration of the Washington Redskins, which were issued in 1967, 74, 78, and 90. The defendants claim that the trademark registration violated the Lanham Act, which forbids registration for trademarks that may be disparaging to persons or bring people into dispute or contempt. So the overview decision of the trademark trial, the Black Horse won the case, as she believed the trademark was slanderous, which the court agreed on. The defendant can profit from the logo but can't be placed on registry, which meaning no collection of treble damages or protecting legal benefits by federal registration.
So kind of moving on into this, Black Horse v. Pro Football was appealed on by Pro Football Inc. and brought to the Fourth Circuit Court, where they took on the case. The Fourth Circuit reviewed the case and overturned the original ruling of the USPTO and ruled in favor of Pro Football Inc., rewarding the use of 6 trademarks back under regulation of free speech. Basically, the appellate court in the Fourth Circuit used Mattel versus Tam, a case that was a precedent set by the Supreme Court of the United States, in which ruled Section 2 of the Lanham Act, a section better known as a disparagement clause, as unconstitutional. Some of the rationale and reasonings behind that included that Black Horse would set a dangerous precedent moving forward by boldly analyzing the First Amendment claim. Further, free speech clause does not regulate government speech, and that the government speech is exempt from the First Amendment liability. Simply put, the government could not decide which viewpoints it liked and did not like under the basis of the First Amendment protections.
So for possible solutions, we've come up with three different ones. Number one is the Florida State Seminoles and how they've been able to do it. So Florida State has had a working relationship with the Seminole tribe for nearly 70 years. All the Seminole tribe itself has say in how the trademark is used and how Florida State is able to use representations of their tribe in certain situations. One of the big instances is during their homecoming, they don't have a king and queen, they have a chief, and they are crowned by members of the tribe itself. So they're able to continuously have a relationship with the Seminole tribe to where the logo is used in a way that can properly show the culture of the tribe itself.
Well, today is our second day of our Brighton Field Day Festival, our 77th annual festival. It's one of the oldest Native American festivals throughout the United States. As you can see, there's a good crowd all over the place, and they're just having a good time. You know, man, Seminole alligator wrestling. We have a lot of Native American dancing. Seminole food. And in combination with our big PRCA rodeo.
We're just demonstrating traditional cooking. We do this every year just to show people how we usually cook. We make use of pretty much any fish. We're just roasting it, and the shell acts as an oven and cooks everything from the inside out.
So you do not want to grab them by the side.
There's so many things going on. It's just hard to pinpoint one thing exactly that's a big hit around here. FSU fans attend this event. They're able to see more of the Seminole culture and learn more about the name that Florida State uses. So I think it's very important to both sides to continue that relationship.
We're probably the only tribe out there that has a strong relationship with the University of Florida State. That it's an opportunity for us to invite them down. Whether like today we have a couple of the football players, and I also got the president of Florida State University, President Thrasher. So it's always good to show that showcase that relationship that we do have. Both share the same name, Seminole, and then at the same time it's about when they're on a football field, it's having that unconquered spirit. And the Seminole tribe, we still have that unconquered spirit.
All right, solution two, the Illinois Fighting Illini. The University of Illinois, in 2006, decided to remove their mascot after the NCAA made a rule banning any hostile and abusive racial, ethnic, or national origin mascots, nicknames, or imagery. The interesting thing is they did this without naming an official successor for their mascot. So the Illinois is called the Fighting Illini, but they don't have an official mascot still. And they're currently voting on different things, different types of mascots. As you can see in the image on the bottom right is a potential for the new one. But something that we've seen is that you can remove it without having an excuse for we don't have another backup mascot or this has been our tradition forever. Chief of Linwick was part of Illinois for decades, and they immediately removed it once they realized that it was offensive and that there was going to be complications with their current mascot.
So for solution three, we came up with the Cleveland Indians, and just recently they actually cut out Chief Wahoo as the official team logo. Rob Manfred, which is the commissioner of the MLB, said he wanted to take steps forward to strive for a goal of diversity and inclusion in the league. So the Indians had been using this logo since 1948, and they finally announced that it would no longer be seen in an on-field setting. However, there was still criticism of the team due to their reluctance to relinquish the trademark itself. They're still able to profit from the image, and they're still able to sell items in their stores at the stadium with this logo on it. They still plan to use the nickname Indians in the future. So the logo was a good step, but if you want to combat the true issue, then all of it needs to go. So for example, St. John's University, Redmen, became the Red Storm in 1994, and another college at the University of North Dakota, where they were once known as the Fighting Sioux and have been the Fighting Hawks since 2015. So another solution to this problem is to adopt the same approach that Florida State University is doing, as I mentioned before, by just kind of honoring the history and the heritage of of Native Americans. If Cleveland plans to keep using this nickname, then they need to honor the culture and possibly even look into splitting the trademark and logo profits with various Native American reserves throughout the country. I think if they do that and kind of honor the history of who they're representing, then that would be a lot better solution than what they're doing now. So furthermore, teams such as the Atlanta Braves and the Redskins should also look into taking a step forward and culture appropriation, because currently they don't really have a plan set. And I know the Braves playoff tomahawk chant and stuff has caused a lot of controversy. So they should really look into doing these solutions as well.